My name is Melanie Jacobs, and I'm professor here as well as our senior associate dean. So I know a lot of you, but don't know all of you, which is why I wanted to introduce myself. And I am so delighted to see you here today. We have a really good crowd, and I'm not at all surprised because I'm very delighted to introduce our speaker, and this is a fascinating topic. So I would love to introduce Dean Lesley Wexler, who joined the Illinois Law School faculty in 2010. She teaches torts, laws of war, and international environmental law. And prior to joining the faculty at Illinois, Professor Wexler taught at Florida State. And prior to that, she was at University of Chicago as a Bigelow Fellow. So, Dean Wexler, I'm saying Dean because I realize you're the new Associate Dean for Academic Affairs, so I want to give you your due. Well, 3 days in is a good thing. So Dean Wexler has broad research interests in international humanitarian law, human rights law, and sex discrimination. She specializes in those areas that reflect the movement of anti-discrimination and humanitarian norms through domestic law, international law, social movements, and corporations. She's written on the legitimacy of targeting decisions, the blood diamond trade, and the regulation of depleted uranium and landmines, along with a series of articles on human rights impact statements. And Dean Wexler's work has drawn on case studies using De Beers, Walmart, and Chick-fil-A. Dean Wexler earned her BA with honors from the University of Michigan. We don't hold that against you. And excellent. And her JD with honors from the University of Chicago Law School. And while in law school, she was on the board of both the Chicago International Law Journal and the Chicago Legal Forum. She has a distinguished career clerking and in practice, and you can tell with this very brief introduction that she will be a fabulous person to discuss with us, talking about what we should discuss when we talk about Me Too in this climate. So please join me in welcoming Dean Wexler. Thank you so much for coming.
Thank you so much for that generous introduction. It's an honor and a privilege to be here. It is my first visit to Lansing because I am a second-generation Wolverine, but it's been really great. I wanted to thank the Talsky Center for Human Rights, Susan Botensky, Marie Gordon, David and Melanie for organizing and coordinating, and research assistance from Jane Kim, Gabriella Dubsky, and Jacob Ferguson, who's actually an MSU alum. So this is a great way for me to start the semester, and I hope for you guys as well. So with apologies to Raymond Carver, I wanted to talk a little bit about how we talk about Me Too when we talk about Me Too, which is to say, Me Too started off as a therapeutic and educational movement, but law came along pretty quickly, and we're starting to see lots of different languages that are being used. So the first part of my talk is just going to be laying out these various ways in which we talk about the Me Too movement. The second part of my talk is going to be the introduction of human rights language. So not very many people know, but there actually is a UN drafted treaty on Me Too that's being debated right now and may be ratified as early as next year. And in the last part of the talk, I want to talk about something I think we're not talking about enough when we talk about Me Too, which is the promise and peril of restorative justice. So as a complementary or alternative approach to this sort of discipline and punish, to educate, to prohibit, there may also be some other things that we should be talking about, but we haven't been talking about enough yet. So with that, I'll get started with the sort of first part of the talk, which is how did Me Too emerge and how did we talk about Me Too when it emerged? So I'm sure all of you remember in October 2017 when the Harvey Weinstein story was broken by the New York Times and the New Yorker magazine. A few days later, Alyssa Milano posted the tweet that was retweeted around the world. Me Too. Suggested by a friend, if all the women who have been sexually harassed or assaulted wrote Me Too as a status, we might give people a sense of the magnitude of the problem. So within less than a month, there were over 2 million tweets spanning 85 countries. So it's not just a phenomenon limited to the United States. And Alyssa Milano sort of commented that her view was that the most important thing that the Me Too tweet did and was doing was to shift the focus away from the perpetrator and to the victims, to the survivors. She wasn't thinking about a legal reform effort. It wasn't a call to action. She didn't have a campaign in mind. And instead, what she wanted was women and men who had been harassed or assaulted simply to raise their hands. And the idea is this hand raising would help dismantle the pre-existing belief that harassment or assault is exceptional. In fact, it's an everyday occurrence. And I think that MeToo has been very successful in this modest educational goal. I think people generally are much more aware, to the extent they weren't aware before, of the prevalence of harassment and assault. But pretty shortly after Alyssa Milano's hashtag MeToo, people started to notice there was another MeToo that long predated this hashtag movement, which was Tarana Burke's MeToo, which was more therapy, more therapeutically oriented. And so it had been a 10-year effort to help survivors of sexual violence, particularly young women of color from low-wealth communities, find pathways to healing. So when Ms. Burke talks about MeToo, she talks about the need for empathy for victims, the need to take the focus off the accuser, to provide community, to dispel isolation, and this idea of solidarity, that survivors should reach out to those who don't yet realize they're survivors and helping them feel whole. In addition to this sort of community-oriented sense, there's also an emphasis, I think, on power and privilege and structure. This idea that instead of focusing on a single event with a single perpetrator, we should be looking at the enablers, the sort of larger setting, the larger cultural and social forces. And pretty soon after the two MeToos came together, Tarana Burke tweeted, "It's beyond a hashtag, it's the start of a longer conversation and a movement for radical community. Join us." And I think for the most part, these two MeToos, one with a therapeutic aim, one with an educational aim, have mostly come together, though it's been a bit uneasy with Ms. Burke sort of emphasizing repeatedly, and to my mind correctly, that sometimes the MeToo movement seems to be amplifying mostly cis women, cis white women, rather than women of color, gay men, poor women. So think of how long it took to get sort of widespread public condemnation of R. Kelly, for example. So we've got sort of two MeToos going on. And you may not have noticed, but there was a third MeToo built in from the beginning, which was Law MeToo, or the ways in which people automatically sort of infuse law into this conversation about sexual violence, sexual harassment, sexual assault. And in some ways, I think that's a very American thing to do. Americans talk about law in all sorts of settings. People from de Tocqueville to Marianne Glendon have sort of noticed that Americans tend to view social problems as legal problems. And I think that's been accelerated by the sort of movement of feminists in the 1980s and the 1990s to turn to criminalization as a way to address domestic violence. So there were some benefits from sort of equalizing, putting domestic violence survivors on the same scale as other victims of violent crimes, but it also meant that the conversation often turns to law instead of other places. So here are some examples in which I think that's happening right now in the MeToo conversation. If you look back at Alyssa Milano's original tweet, if you've been sexually harassed or assaulted, you guys are law students. Those are legal terms of art. Now, she may not have meant them as legal terms of art. She may have just been thinking sort of conversationally, what do I call this practice, harassment or assault? But I don't think it's an accident that she used legal terms, because I think that it's very common for Americans to sort of frame our experiences by the law. There's a positive side to that, which is it's familiar. People sort of generally have an idea of what you mean. You don't have to sort of start from scratch. But the downside is it may mean that women or men experience things that feel violating, coercive, but don't meet the legal standards, and then they are told on Facebook, on Twitter, in personal conversations in offices, oh, no, you're not a MeToo survivor. You're not part of this. We're not talking about microaggressions. We're only talking about something that rises to the level of a Title VII violation or a Title IX violation. But there's obviously lots of behavior that society is trying to grapple with that I sort of put in the category of lawful but awful, right? So Aziz Ansari's date gone bad. Probably not a crime. Probably not a tort, although even those things can be debated. But to say that the woman who went on that date can't be part of the Me Too conversation, or that we shouldn't be thinking about those sort of settings, I think is one of the limitations of using law as a way to talk about Me Too. A second way in which we see this happen is this idea that legal forums can act as a gatekeeping function. So you often see when you read comments, which you should never do, right? Comments to newspaper articles. The only people who should be coming forward, the only people that we should be listening to are people who already reported, people who went to the cops. Otherwise, right, until they're willing to come forward, they don't deserve our listening, they don't deserve our empathy unless they're willing to sort of initiate legal mechanisms. Some go even further than that. So some will say, and in fact, the only place you should be having this conversation is in a court of law. If you want to say that someone harassed you, you want to say that someone raped you, then the proper place to have that conversation is in front of a judge and jury, and not on your social media, not with your friends, not with your boss. Process. What rules guide our determination? I don't know about you guys, but I could not turn away from sort of the spectacle of the Kavanaugh nomination and all of the ensuing commentary. And a lot of it revolved around these legal questions. What standard of proof should be used in a confirmation hearing? Is there tampering with witnesses? Is there corroboration? And I understand why people found it helpful and comforting to look to the law to help guide the determination process. But of course, there's nothing in the confirmation process that demands we use criminal standards of evidence, criminal standards of proof, or even a tort standard, right? We could use whatever we want, but there was sort of a strong presumption that, well, why wouldn't we use what the criminal law uses? And I also think we see it a bit when people discuss the consequences. This idea that people who lose their jobs or face social sanctions are suffering the death penalty, that the responses are disproportionate, and that it's cruel and unusual punishment, that making a determination about someone's wrongdoing outside of a court is mob justice, is vigilantism, is a witch hunt. And I think this is shaping sort of the boundaries of what people are feeling comfortable, sort of what's in and what's outside of Me Too. But at the same time, we're also seeing a lot of sort of subgroup communities, different sort of cultures turn to their own sort of internal languages. So one of the places in which I saw this was hashtag #MosqueMeToo. So in February 2018, a New York Times freelancer and Pakistani woman described how she had been harassed during her Hajj and asked other women to join in. And it was retweeted approximately 25,000 times. As you can see, not just in the United States, but also sort of around the globe, but mostly, obviously, for people who were sort of going on this journey. And when you look at the conversation that #MosqueMeToo sparked, it sort of happened in two ways. One conversation was happening within the language of rights. So the originator of this tweet sort of said, when I say I own my body, it doesn't belong to the state, it doesn't belong to the street, it doesn't belong to the home or the church or the mosque or the temple. It's my right to choose who to have sex with, so long as they consent whenever I choose. You can't prevent me from exercising my rights. So that was sort of a secular vision. It was pretty consistent with our sort of larger legal conversation about what consent is. But there was a second conversation that started bubbling up about using religious rules and religious norms to bolster the voices of survivors. So rather than referencing sort of their rights under the Constitution or their local country's law, they sort of emphasized the teachings of Prophet Muhammad and other sort of doctrine and rules within the religion that would prohibit this practice. We see something similar with the Church Too movement. So again, this idea, part of the Church Too movement is to foster awareness and community for women and men to find other survivors, to sort of discuss their experiences, particularly within evangelical churches. And to some extent, they, much like the sort of larger MeToo movement, have had some success. So these are pictures of people who are sort of pastors of mega churches who have either resigned or been fired, although it's been an interesting reshuffling. So this guy gets fired, but then becomes an emeritus professor of the Theological Institute and seems to be paid exactly the same amount of money. You know, that happens. But again, here too, instead of mirroring the sort of larger conversation in the United States about Me Too, about consent, the conversation here has been a lot about purity culture, this idea that is part of why Me Too is so prevalent in this institution in particular, because women are told to be subservient to men, to be meek, to be modest, to be self-sacrificing. And is that purity culture itself part of sort of complementarianism, which is a philosophy that says men and women are of equal worth before God, but they have separate but complementary roles. So some have interpreted that to mean women cannot lead megachurches or churches at all, don't have a role to play in reforming. And so the Church Too movement has really started to link these ideas together, right? This idea that misogyny and lack of equal pay, lack of equal access to jobs is part and parcel of this conversation about why harassment, why assault is so prevalent. But at the same time, many churches, in sort of trying to resolve particular disputes, often employ conciliation services that are rooted, not surprisingly, in sort of Christian doctrine and theology, and are often counseling victims and congregations to forgive offenders, that we need to accept God's grace, it's not for us to condemn, and we should be more focused on whether the offenders repent than what it is that the victim thinks is an appropriate response. And for those women and men who have found that sort of unsatisfying, they're a bit more limited than some others in turning to the law. Why? Title VII has an exception that limits its sort of applicability, at least in hiring and firing discrimination suits. It's sort of not really clear, honestly, whether Title VII would allow for harassment suits in certain contexts. And so that's a nice place to sort of, if that's how we've been talking about Me Too, sort of some large national conversation that's partly about education, partly about therapy, largely wrapped up in the law, with individual communities turning to their own rules and laws and norms to think about Me Too. There's also a sort of much broader movement that is sort of starting at the top that says, well, whatever it is that we're going to say about Me Too, we should be saying it with reference to human rights language, not sort of our domestic Title VII, Title IX, but international human rights language. So the International Labor Organization, which is a special body of the United Nations, is working on a convention called the Treaty on Violence and Harassment in the World of Work, which I've helpfully shortened to the Me Too Treaty because I think that's a little catchier. This is unique, right? So the International Labor Organization has labor standards on violence and harassment, but they are largely either limited to specific groups. So they have a convention on indigenous and tribal peoples that includes anti-harassment provisions. But they don't have any sort of broad brush anti-violence, anti-harassment treatment that extends sort of to all workplaces, all countries more generally. So how did this happen? It actually predated the MeToo movement. So about 10 years ago, the ILO decided to start studying what they perceived might be a problem. And after about 6 years of compiling evidence and surveys of various member countries, they said, you know, this is a significant enough problem that we think we need an international treaty as opposed to maybe just some soft law or maybe just some recommendations. And the ILO is interesting in that their sort of process works in that it's not just member states at the table talking about the treaty, drafting the treaty, doing the background research. They also include workers' organizations and employers' organizations. So they try to have sort of everyone with a seat at the table to be giving input. Although that said, not surprisingly, only states actually get a vote on the treaty since they're going to be the ones governed by it. And after all of these meetings, they decided, in fact, why do we need a treaty? Of the 189 countries they studied, 59 of them had no specific sexual harassment and employment laws at all. The other countries, they said, for the most part, had gaps that meant workers who were in workplaces where they were the most likely to be harassed. So migrant workers, farm workers, factory workers, people who are sort of had the least amount of power, were the most physically isolated, socially isolated, tended not to have coverage. And they also thought that the countries that did have broader coverage often sort of didn't have great definitions of what would count as harassment or didn't have a particularly nuanced introduction. So what's the upside of thinking about MeToo as a human rights problem and relatedly drafting a human rights treaty? So one is that once signed and ratified, it's binding. So 15 years from now, a country elects a new leader, they decide to move in a different direction. Of course, they can undo even treaty work, but it's more costly, it's more visible, right? They would have to exit the treaty publicly, which they may not be willing to do. It facilitates sharing best practices. So the treaty has an information gathering mechanism, which is the next one, and then countries can see and piggyback off of each other's efforts. They can say, what's a country that looks a lot like us, that has similar problems? What are they doing? Did it work? Should we do that as well? Let's share what we've been doing, as well as sort of information more generally about the prevalence of the problem, whether there are things they just didn't think about in sort of the first iteration of the treaty. Harmonize across nations. So if you are a worker who lives in the Philippines and you go to a neighboring country to be a domestic worker, you would have the same, at least core sort of basic rights and respects that you would get in your home country. I also think, honestly, for me, some of the most important part of this is about messaging. If you've taken employment discrimination, you may know that Title VII's inclusion of sex discrimination was not, well, it was intentional, but it wasn't to combat sex discrimination. The thought was, if we add this to the legislation, it probably won't get the necessary votes and it'll sink the legislation. So I wouldn't say it was a piece of legislation that thought seriously and deeply about the problems people faced in the workplace due to sex discrimination. Contrast this with a treaty that sort of says at its very heart, what we are most concerned with is gender-based violence and harassment, that we think that's a serious problem and one at which we want to sort of think about how to address from the very start. So what's in the treaty? The preamble, steeped in the language of human rights, says, all humans have the right to pursue material well-being and conditions of freedom and dignity, of economic security and equal opportunity. And one thing that's nice about doing this is it suggests that the right to be free from violence and harassment, as it discusses later in the treaty, is on par with other human rights, that it is as important as civil rights. I would say economic rights, but we're not a big joiner of economic rights treaties, but as important as they are to at least others. Something else interesting that the treaty does is it sort of started off 10 years ago thinking it was going to focus on physical violence. And over time decided we need to broaden that scope. We need to include a range of unacceptable practices and behaviors or threats, whether single occurrence or repeated, that aim at or result in physical, psychological, sexual, or economic harm, including gender-based violence or harassment. That is sort of a breathtaking scope as compared to our domestic interpretation of severe or pervasive under Title VII, or the heightened standard that I think we're likely to get under Title IX. So the suggestion is this is a much broader understanding of all of the ways in which sort of this phenomena that MeToo is concerned with can take place in the workplace, and thinking about how to sort of address those. It's not only about the intent of the perpetrator, it's about the effect that it has on the victim or the survivor. Some other interesting things in the treaty is that it defines gender-based violence as that violence which occurs because of sex or gender or affect people of sex or gender disproportionately. One really important thing is that this builds in protections for the LGBT community in a way that has not happened, or people have really been struggling for under Title VII. So when you look at sort of the documents the International Labor Organization is producing, they explicitly say things like, you know, harassing gay men or bisexual men or women for not conforming to gender stereotypes is part of what we are directly trying to address. Now, it doesn't say explicitly that it includes any of those groups or non-binary folks, but I think it's sort of much more likely and obvious that it would than under our sort of Title VII or Title IX. It also has a broader definition of worker, so no minimum definition of the number of people in a workplace. It includes interns, trainees, volunteers, and applicants. It includes work-related social activities, work-related communications, employer-provided accommodations. When you look at the treaty itself and what it requires, that doesn't look so different. So it prohibits violence and harassment. It demands that states implement sort of relevant policies to do so, that they provide sanctions, that they provide education and training, inspection and investigation. But some of the ways in which they try to realize these requirements are interesting. So for example, the International Labor Organization emphasizes the right to collective bargaining as being part of a way to sort of realize these rights, which is the opposite direction than the United States is. Right. There's been much more sort of emphasis on individual arbitration, on weakening rather than strengthening the power of unions. What else is in there? Lots of complaint and investigation mechanisms, and a sort of willingness to experiment. So they talk about some programs that they've tried. Sorry, go back. A program called the Better Work Program, which is an ILO program, which has tried to address harassment and assault in the global garment supply chain by doing some fairly traditional things, so education, increasing reporting mechanisms, but also targeting mid and upper level management to hire more internally. Why hire more internally? Because often the line workers are women and middle and upper management are men. And the ILO felt like that was part of why harassment was so pervasive, that there wasn't a sort of strong female voice being represented at either sort of mid-management or upper management. Women didn't have people that they felt they could complain to that had any power. They also thought that if there were more women in power, that may itself change the culture, help shift dynamics. And there is some sort of good evidence for this coming out of the ILO program. But I'm always cautious about this because there's also a really good study that was published recently that in the United States, female supervisors are actually the most likely people to be harassed, not the least because this sort of notion that they shouldn't be the ones holding the power is part of what encourages the harassment to continue. So at this point, I thought it might be interesting to look at a specific place that's not the United States and get a sense of how Me Too and Me Too dynamics are sort of working through that country, and then we can think about, as sort of the last section, what would it mean in addition to sort of human rights language, domestic law language, religious norm language, education law language, to think about restorative justice in this setting. So in Brazil, in 2000, let's see, let me skip it. Oh, so in 2015, feminists launched a hashtag, right, long before Me Too, called My First Harassment, after male viewers of a popular cooking show tweeted overtly sexual remarks to a 12-year-old contestant. And this sort of spawned hundreds of thousands of tweets about women sort of coming forward and saying the first time they were harassed. It led to a second hashtag called My Anonymous Friend, so women who were documenting harassment that happened on the street, in the workplace. I don't know, did any of you see the sportscaster who was sort of televised after a soccer match, and someone just comes up from the crowd and starts kissing her while she's giving her sports report? And so she spawned another hashtag, Let Her Do Her Job, which caused 100 female sportscasters in Brazil to sort of spread their experience with harassment. And we see Brazil trying to take some efforts here. So they have criminalized sexual harassment. So you can actually go to jail, but only for quid pro quo. So only if you say, you know, sleep with me or I'll fire you, as opposed to some of the other forms of harassment that we might see. There were no sort of civil suits for harassment. That's starting to change. So we see the labor code saying, well, even if it's not sort of what Americans would recognize as a tort lawsuit, maybe moral damages are appropriate when women are harassed. They've taken some other sort of generally pro-women stances, like criminalizing femicide or gender-motivated crimes and improving reporting. But at the same time, so this was Brazil's 2 presidents ago, female president who was sort of taken down in what some saw as a gender-motivated, scandal. And the new president is thought to be sort of not moving in the same direction as much of Brazilian society, so has said some horrible things about the female president, former female president. But even as he sort of has been moving in the wrong direction, public prosecutors are starting to take more cases. So John of God is a very high-profile faith leader, and they are starting to prosecute him. Right, but it's a mixed story. So this was Marielle Franco, who is one of Brazil's few Black female politicians. She was an out lesbian, an outspoken human rights advocate, was sort of part of this larger movement for social change, partially dealing with sort of Me Too issues, partially sort of larger issues trying to get the police out of the favelas, murdered. It's never been resolved. And so I wanted to think about, you know, to the extent that laws alone, so either a treaty coming from on high or a state itself deciding to implement more or better legislation or legislative coverage, I hope all of those things will happen, and I think they're an important part of the Me Too conversation. But I think one part of the story that's missing is the story of restorative justice. So back at the Golden Globes in 2018, Laura Dern came forward when she was accepting her award and said, I urge all of us not only to support survivors and bystanders who are brave enough to tell their truth, but to promote restorative justice. May we also please protect and employ them. May we teach our children that speaking out without fear of retribution is our culture's new North Star. This is actually what prompted sort of my paper on Me Too, is the morning after this speech, I went into my colleague's office who writes about restorative justice, and I said, what do you think she's talking about? And my colleague was like, I have no idea. There are a million things that could count as restorative justice, and I'm not sure from this really short clip kind of what her vision of it is. So one vision of restorative justice, which I think is sort of most consistent with what she said, is focusing on victims and survivors. So to make sure that women and men who have been subject to harassment and violence in the workplace can be restored and reintegrated. So when we think about women like Rose McGowan or Annabella Sciorra who say, you know, not only was I harassed and assaulted by Harvey Weinstein, but my career basically ended at that point because I started getting blackballed. Or someone like Hillary Burton who said, I was so sort of pervasively harassed at work that I just never wanted to sort of be in a position where that could happen to me. So she just took herself out of the workplace and hasn't really come back. So one vision of restorative justice says, look, it's important to talk about Harvey Weinstein, but it's also important to talk about what are we doing to help the survivors, right? And merely prosecuting or firing their perpetrators doesn't make victims and survivors whole, right? And so what would that look like? But that's not usually what academics mean when they talk about restorative justice. That's usually part of it, right? But not sort of the whole vision. The sort of larger vision of restorative justice usually means sort of direct participation both by survivors but also by perpetrators and the community at large to sort of think about acts of wrongdoing, how they affected the survivor, how they affect the community. And some of the core commitments include a sort of a narration of wrongful behavior and how it affected the victim, getting the perpetrator to acknowledge the offense, the wrongdoing, and accept responsibility, to repair the harm that was done to the victim, and to think about ways in which to sort of incorporate both of them back into the community. So I feel like, at least in the United States, we've been having a big conversation about, well, when does Louis C.K. get to come back? When does Matt Lauer get to come back? That's a very unsophisticated way of thinking about restorative justice and what it means to reintegrate offenders. It's not simply a question of time served, but of doing the work, right? Doing the work of restorative justice. So what does that mean? One thing that's really important to victims is they want acknowledgement, sometimes by their perpetrator, but often by the larger community of what happened to them, right? I say the following things happened to me and you believe me. So some victims want the chance to tell their own stories. Others want the perpetrator to sort of narrate it back and say, yes, these things did happen. Sometimes what they want is to have the perpetrator hear it, right? It's not just about being fired, but I want you to sit in a room and look at me while I tell you the ways in which you harmed me. Contrast those with conditional apologies. Bob Packwood, right, bless his heart, I'm apologizing for the conduct that it was alleged that I did. That is pretty unsatisfying. Jeffrey Tambor, I'm deeply sorry if any action of mine was ever misinterpreted by anyone as being sexually aggressive, or if I ever offended or hurt anyone. Conditional apologies like this are counterproductive because they suggest either the underlying account is untrue or the fault is the survivors for being too sensitive, for not really sort of being willing to go along and get along. I could give you a million examples of bad apologies that don't count as apologies for restorative justice. Finding really good apologies is harder, but I did find, I think, a pretty good one. So Megan Gantz was a showrunner for Dan Harmon while he was on the show Community, and she had put on social media a fairly lengthy account of the ways in which he had harassed her, he had gaslighted her, he had sort of made it incredibly difficult for her to survive in the workplace, and called for a public apology, which it turns out he actually gave her. So he has a podcast in which he spends about half an hour describing the various things that he did and explaining, both that they were true and the ways in which it must have made it difficult for her to sort of be in the workplace. And she accepted, right? She sort of said, I never expected to sort of get this, but I did, and I choose to forgive both privately and publicly. Victims also want sort of individual acknowledgement. So for all of Louis C.K.'s fault, he did explicitly acknowledge the people that he harassed, as opposed to these more generic, I'm sorry if anyone, or to any, these sort of almost victimless crimes, right? He acknowledges there are specific women to whom he caused harm. What else do women want, or what else do victims and survivors want? So she probably looks pretty familiar to most of you. This idea that wrongdoers should accept responsibility or be held accountable. So not merely acknowledging that what happened was true, though that's important, but also acknowledging their role and being willing to sort of make amends. In the criminal justice setting, when restorative justice approaches are available, they're usually only available to those offenders who have first said, I am willing to acknowledge my fault, right? So we don't just sort of jump ahead and say, everybody gets restorative justice, everyone gets forgiven, right? There's work that you have to do. And I think most importantly, Rachel Denhollander notes that it's not just the individual perpetrator. It's the institutions that didn't act, that enabled, that facilitated, that harassment and assault in workplaces aren't just a story of two people. They're a story of two people within a culture, within an institution, within a society, and asking everyone in that community to take a hard look and think about the role that they played or didn't play in harassment or assault, and that the refusal to do so is its own harm, right? The harm is not just what the harasser did, it's also in the failed institutional responses. So to the extent that institutions or individuals are willing and able to take responsibility, what comes next? So I have a 4-year-old daughter, which means I watch a lot of Daniel Tiger. And it's such a simple idea, but one that I really have been surprised is not part of the MeToo conversation. I'm sorry is the first step. It's not the last step. I'm sorry is the first step. Now, how can I help? I think to too many, the MeToo conversation has become a, well, just apologize, and then the script is, you get forgiven. But that's missing sort of the responsibility, taking all these other steps. In addition, thinking about what it is that survivors want and need. How can they be healed? For some, money helps, right? You need money to get psychiatric care, to get basic health care, to make yourself feel better. Americans, right, the tort system is premised on the idea that money is the best thing that we have to making you whole. It's not perfect, but that's generally how we try to make people better when they have been wronged. But yet for victims of sexual harassment and sexual assault, there's this stigma that if you want money to make yourself whole, oh, well then you must be a gold digger, you must be lying. You can only want money in order to give it to others. So Amber Heard says, I'm gonna take my divorce settlement and give it to other battered women. A laudable thing to do. Many survivors are sort of outwardly oriented, want to help others in the community. But that certainly shouldn't be a requirement, right? So one thing that can help repair is money. One thing that helps is letting victims say what it is they want. So some victims, survivors want punishment, others don't, right? They may want something different. They may want sort of the structure to change, and they may have ideas about how to do that. What does it mean then for perpetrators to be restored and reintegrated? So if they've gone through these other steps. And again, here it was a lot easier to find bad examples than good examples. So you can point to lots of sort of MeToo perpetrators and say, they have not done all the things that I've just outlined. They've done one, they've done two, they've done none. And this one sort of surprised me, but as I read more and more, I became sort of more convinced. So Ray Rice, as many of you may know, assaulted his then girlfriend, now wife, in an elevator, and it was made public. He lost his job. And so the first kind of set of things that he did, I think it was easy to say, well, you know, he said he was sorry, he's trying to get his job back, what else do you expect? But is that really enough? So here we are several years later, he's still in personal therapy, he speaks publicly frequently about his remorse, he teaches about domestic violence and decision-making to young men, he volunteers as a mentor. I don't know whether any of this is sincere. I think it is, but even if it's not sincere, I'm not sure that sincerity is what's most important. I think what's most important is he is publicly committing himself to explaining why he did what he was wrong and trying to make things better. So contrast that, for example, with convicted rapist Brock Turner's office to speak to undergraduates about the hazards of excessive drinking. Right? That's not making amends. That's saying, well, the problem was alcohol, not that I violated someone without their consent. But it's a lot easier to find Brock Turner's than it is to find Ray Rice's. But I think part of what we should be talking about when we talk about Me Too is being creative, being imaginative. What would this look like, right? What else should we add in here? I guess I'll just sort of end with thinking about forgiveness and what that might mean in this setting. So we talked a little bit about what's called a script, this idea in conversations that when you're wronged, if someone apologizes, the appropriate response is to say, "Thank you, I forgive you." And I don't think that script is right in the restorative justice setting, in the harassment setting, in the violence setting, right? It's not just the "I'm sorry," it's got to be the "I'm sorry, how can I help?" But even if we have sort of the best example that we can think of, so someone who publicly acknowledges harm, tries to repair, undergoes therapy, continues to work on themselves, etc., are survivors sort of obligated to forgive? And what would it mean to forgive in this setting? So forgiveness, at least in the psychology literature, is understood as a decision to release or forgo bitterness and vengeance that may or may not involve a change in emotions or attitudes towards the offender. So for psychologists, forgiveness is really about the forgiver, right? This is a way for survivors to help heal and let go, but it doesn't demand that they continue to interact with their offender. It doesn't mean that they have to absolve them of feelings of wrongdoing, right? It's a much more internal process. And forgiveness, most importantly, does not mean that offenders aren't supposed to be held accountable, right? It doesn't mean that if the victim or survivor says, "I forgive you," that the community should not still be demanding various forms of accountability. So psychologists sort of say, forgiveness is not denying, excusing, minimizing, or tolerating an offense. It ought to take seriously the safety of victims and justice-oriented responses to the offenders. And the reason I wanted to emphasize this is as Title IX is being likely changed, one of the things that is going to be possible as part of Title IX proceedings are things that look like restorative justice, this idea that instead of going through sort of a formal legal process with formal sanctions, there may be more informal mediation. And I'm sort of torn about this. In theory, I think that can be a good idea. I think there are some victims to whom that would be a more appealing approach than the sort of more formal legal approach. But in practice, I worry a lot that survivors will be pressured to accept apologies and move on, to say that's sufficient as long as this person sort of went through the script, you need to do that. And I also worry that when people talk about forgiveness, we see this in the Church 2 conversation, that forgiveness is not the same thing as restoring an offender to a prior position, and it doesn't mean that a survivor must reconcile, and forgiveness does not imply forgetting, either for the victim or for the community, for the institution, for the perpetrator. And so I guess I'll just close with sort of an anecdote, which is the New York Times recently did a roundtable with the cast of Arrested Development while they were sort of going on their tour for their latest Netflix series. And the issue of Jeffrey Tambor's harassment on the set of Transparent came up, and then it was sort of revealed that he had harassed Jessica Walters, not sexually, but that he had been sort of verbally abusive. And it was such a sort of unpleasant setting in which all of her male colleagues defended Jeffrey Tambor, that Jessica Walters started weeping and said, basically, I have to let it go. I have to give it up. And some people who were present at the moment said, oh, isn't that nice? She forgives, she sort of gives up her harassment. But that's not how I read that moment at all. I saw her as being pressured. If you want to stay on the show, we've chosen sides, we've chosen Jeffrey. And she realized, I'm going to be blamed for holding a grudge if I don't publicly forgive. And that pressure to forgive is itself another harm that can occur to MeToo survivors if we're not careful about the way in which we talk about MeToo. So with that, I'll stop, and I'm happy to take questions for as long as you want to ask them. So thank you.
I'm happy to start keeping a queue. So as I see hands, I'll... Okay.
Is this a talk that you give at other law schools also?
So I've given versions of it. So I have a paper, I shouldn't say we. So I have two co-authors that we wrote a paper called Me Too and Theories of Justice that largely focuses on this idea of restorative justice, and we also talk a bit about transitional justice. And then I have another talk that I've given that's just about the sort of law talk part. So yeah, I talk about this a lot, but this might be the last one for a little while because associate deaning tends to, but if you have a thought of someone else.
Two-part question.
Yeah.
So I noticed this room appears to be almost all women, and I'm wondering if
I noticed that too.
any insight about how other schools advertise the event, if there's something that they're doing differently than we are to get a more balance. And I don't mean this as a critique of anyone who helped organize this. Thank you.
Yeah, it's a good question of how to be inclusive, and it's something that I think about all the time because it's a real tightrope, right? So there are things that I want to say to my colleagues, and sometimes I say them and sometimes I don't because I think if I say this person is going to disengage from the conversation. So how do you sort of say we all need to be having this conversation and we don't want you to opt out, but to say it in a way that isn't, right? When you say it in an accusatory way, it's all the more reason that someone says, well, then I'm opting out because I don't want to be barraged with it's my fault for an hour. And I don't know that I have a good answer other than, honestly, I think that sort of small interpersonal work, right? So picking a handful of people, right? You've got some guy friends. I'm going to go to this talk. I'd really like it if you came with me, and here's why I'd really like it if you come with me. And I think that sort of non-confrontational, small setting as opposed to the sort of, I bet the student population is close to 50-50, and yet the representation here is not right? So, but that's just a sort of, I have found when I am able to engage in that way that I've had better luck than in the sort of, I'm just so angry, right? So, but sometimes you just have to be angry and express that anger too. And so it's sometimes you do, sometimes you don't. I wish I had a better answer for you.
That's all right. Professor Kirkendall, did you?
Well, I will defer if there's students who have something first.
I'm just going to keep a...
All right, well, shall I? I'd like to ask about the possibility that the broad cultural factors may create quite a few leaks in the restorative justice picture. And I have a few, well, for one thing, the big payouts that I believe maybe Matt, what's his name, got a big payout. CBS held the line. I noticed Martha Minow was on the board of CBS and that nothing happened for quite some, so the broad culture can pick up a lot of people potentially. But like, for instance, there was one malefactor whose victims were dogs, and it's not possible to apologize to the dogs. He went to prison, but he's now an accepted cultural figure. What else? Well, so in other words, any general moral accounting seems to be elusive because there are broad cultural factors demonstrated by the attendance here, perhaps, that complicate. Oh, but another one I wanted to mention was there's a whole thing about male authors being lionized, and if you follow the David Foster Wallace story about what he did to Mary Carr, so he's dead. He can't apologize, but there's many outlets continue to lionize David Foster Wallace and basically dismiss Mary Carr, who's also a significant writer, as of no consequence in effect. So, I'm not sure, in other words, my question is, can restorative justice make much of a dent? And you're sort of saying, well, person to person, try to get,
Yeah.
But it seems like a major leak.
Yeah, I think it can't only be restorative justice, right? I see that as a complement to many of the other things that are going on. I also think, right, so we have lots of, I mean, MeToo is sort of filled with lots of bad news stories. But there are some more complicated stories. So think about the way that Junot Diaz was treated sort of in the wake of his revelations and then sort of other women coming forward saying, well, you know, you're telling the story of your abuse, but you're leaving out sort of all of these women in the workplace that you harassed as opposed to sort of talking about the girlfriend that you did. And I feel like that got a fair amount of traction. So I can think of, you know, in any sort of individual community, so the literary community, I can think of a few high-profile examples where it seems like the Me Too movement is making some inroads, right? But it's much like in any other setting, it's uneven, which is to say, sometimes there's something that makes it particularly salient. Sometimes, I mean, honestly, I think numerosity matters a lot. So for David Foster Wallace, I think there's still this sense of, well, Mary Carr is one woman. If it had been 15 women that had come forward, I think people might behave differently. And that is its own problem, right? This idea, you know, why does Bill Cosby go down? Because there are 90 women on the cover of New York Magazine, right? That part of sort of believe all women, I think, when at its root is start by believing one woman. And that's a larger cultural problem, right? And so restorative, I mean, lots of these individual mechanisms can't work without a larger, if the community doesn't believe women, then restorative justice probably is not going to work very well. Yeah.
Well, just to be pedantic as usual, I mean, they don't disbelieve Mary Carr. They simply don't think it's important. They love him. They love the great male author. And even a very fine female author is, you know, it's the same story with that fellow, what's his name in Maine?
Woody Allen?
No, you know, the writer of Catcher in the Rye.
Salinger.
And so the woman that he, you know,
yeah,
manipulated.
Yeah, so
remains under attack for telling what he did to her.
Yeah, yes and no, right? So in both of these settings, right, it's sort of by whom. I think there are people who both believe Mary Carr and care. And there's still a question of sort of what, you know, just the larger question of what do you do with an artist's work when you think the artist, him or herself, is repugnant? And I was at a Me Too conference recently where Marianne Case sort of hilariously said, you know, in response to Woody Allen, I don't care so much about whether we watch his movies. I care about what happens to Woody Allen, not Woody Allen's art. What can you do to sort of David Foster Wallace? I mean, something I've been thinking about is when I read about various artists who are being appreciated, whether alive or posthumously, is, you know, writing letters to the editors saying this part of the story needs to be included. If you're going to write an expose about Chuck Close, then you need to include information about how he harasses his models. It doesn't mean you can't write an article about Chuck Close. It doesn't mean you can't love his photography, but this has got to be part of the story. And I think there are ways in which that happens sometimes, but not all of the time. So think of, you know, David Edelstein gets fired for talking about Bertolucci and the butter scene, right? So there are bad stories, but there are also stories that seem to suggest people do care at least some of the time, which I think is a step forward from where we were in October 2017. but it's slow, right? Big cultural change doesn't happen quickly, and it doesn't happen painlessly.
I know I had some other hands, so I want to. Yes, go ahead.
So as like a room full of women who are going to be lawyers, what advice do you have for us that we're going into like a heavily male-dominated field, especially when we're choosing to work at big law firms? What advice do you have for us?
That's a good question. So strong female mentorship, right? So even if the mentor might not, ideally in your own workplace, but if you can't in sort of in other workplaces, female allies, male allies, right? There are lots of men who want to do the right thing, some of whom know what that is, some of whom are kind of struggling to figure out what that is and trying to identify those individuals. Some of it is about sort of being that person for someone else, right? And so looking outwards and trying to see instances in which you sort of think you can make a positive change for other sort of young lawyers. So this has been happening sort of informally for a long time. So big law firms have always had a whisper network where someone comes to your office and sort of says, and you know, when you go out to the drinking event tonight, make sure to steer clear of so-and-so, or female associates who will, or male associates who will just put physically their body between your body and so, right? So I think strategizing about ways to deal with different kinds of workplace problems with your allies, be they female or male, finding mentors, when you have the ability to do it, which is not always to sort of fight for particular kinds of change. So for example, some law schools have refused to have their students, some law students have refused to interview for workplaces that have mandatory arbitration clauses for Title VII. And not all law students sort of have the market power to do that. And I don't think anyone's suggesting sort of you have to take all the personal risk yourself, but when you can find opportunities to act collectively and reduce the risk to yourself, do it, and to think creatively about what those opportunities might be.
And I think I thought I saw Devaneen here earlier. I think that would be a good conversation for us to continue. That's great with, be it the Diversity Task Force or the Women's Law Caucus, because we've been talking about those conversations and bringing in practitioners to hear that kind of advice and suggestions from multiple sources and know that you're not alone. And your professors, of course, because we've also all been in the workplace and have an opinion. So I think that's a really important question that goes beyond our discussion. It's important today and also should continue, so I just hope that you'll raise it again. Just my own personal pitch.
And maybe one quick additional add, so, you know, sort of researching this and writing about this and thinking about this all the time is often a depressing endeavor. But there are these sort of moments of bright and shining hope. So as you may or may not know, Illinois had its own MeToo scandal pretty recently in November. So one of our colleagues had been engaging in inappropriate behavior. A Title IX report was leaked, and there was a town hall with the students sort of discussing what the law school was entitled to do going forward, given that the Title IX office had not made a finding of a Title IX violation. So it was an example of lawful but awful behavior, at least according to the Title IX officer. And what really surprised and heartened me was as students sort of came to the microphone to ask the dean questions, you know, a male student came up and said, well, what if all of us refuse to take classes from this professor? Does that change anything? And sort of the feeling I got of sort of solidarity among the class that it wasn't only a women's issue. And I don't know why this feeling of solidarity developed, but it did, right? And I think it can, right? There's nothing distinctive about that environment. And so, you know, whatever it is that we can do to sort of foster that sense of solidarity, I think makes, you know, right now, the cost for any one woman are very high. But if you spread it across women and men, it makes it a lot easier, right? Collective action works for a good reason.
Mr. Crossell?
Yeah, I had a question about, so you and your colleagues started thinking about Me Too and writing about Me Too,
did it have an impact on the curriculum or on the courses or on the way you're teaching your courses? What do you think are the offerings that we should be thinking about within the law schools as part of this legal moment?
Yeah, it's a good question. So I don't know that it's changed our course offering, like per se. So classes that are being offered, we have sort of an employment discrimination class. We have some sort of psychology and the law classes that deal with restorative justice. We have transitional justice classes that include a gender component to them. I certainly think that we could do more, but I also am not sure that we have the faculty capacity for it, right? Which is part of, so some of this has to do with faculty hiring, you know, what are the interests of the people that you hire and what kinds of courses are they likely willing and able to teach? And so thinking about that when you're doing hiring. I do think it has changed, I hope, to the good, sort of the willingness to see microaggressions and sort of things that fall under the Title VII radar or the Title IX radar as also problematic. And I don't think that change has been universal, but I do think there are a lot of people who sort of didn't think about it before who think about it now, largely because they're being asked to think about it a lot. And will it be a sustainable change? I hope so. So another thing that's happening is the Faculty Senate is revising our code of conduct. So as Title IX will make it more difficult to kind of reach legal resolution, well, it won't make it harder to reach legal resolution. It will make it harder for victims and survivors to identify what has happened to them as a violation of Title IX. As that threshold is going up, our Faculty Senate is working on bringing the code of conduct threshold down. And so the hope is now that's harder, right? So instead of having one federal law for everybody, each university, are they going to amend their code of conduct or not? But it is a different mechanism that I'm hopeful about, cautiously hopeful about. And I think I saw him.
Yes. So I'm just curious because, like, it's different. Well, how am I going to phrase this? It never gets old getting called on and then being like a jumble of ideas in your head. But so I was in a class earlier in the semester, and Judge Kaczynski came up, and then I Googled who he was and figured out that, like, he had this big scandal with one of his clerks. And it got me thinking while you were speaking about isolated areas of employment.
Yeah.
She wrote this big article, I guess, talking about how she wasn't allowed to talk about what he was doing because of the confidentiality requirement with clerks, if I'm remembering correctly. Mm-hmm. So, like, how does restorative justice apply to law when the law is like a judge is the person who either addresses or resolves or publicizes this sort of thing?
Yeah. So restorative justice is an interesting idea, but certain conditions have to be in place, right? And one of them is you have to have willing participants. And Judge Kaczynski, not a willing participant, right? But what could be done to make some judges more likely to be willing participants? So Leah Littman and some others have started I don't remember the formal title for it, but a sort of group of former clerks that are trying to get the federal judges to amend some of the procedures that they have. So some of it is, you know, you can change the rules to make the rules work better. But sometimes there's a recognition that the rules aren't fundamentally the problem, right? The reason the rule is the way it is because of some deeper underlying problem. And in those settings, it may be that publicity, right? Transparency works better. So, and I think I met the Kaczynski clerk that you're alluding to. And I mean, I think she's a really interesting example of the sort of restorative process, which is to say, she found this experience with Judge Kaczynski so traumatizing. I met her the year she went on the academic market and thought sort of, she was an unusual candidate and seemed sort of oddly disinterested in getting a job with us. And it's that, which is not generally what you see in a job candidate. And it didn't make sense at the time, but it makes sense now, right? That she was sort of fresh off this trauma. She didn't want to be anywhere but sort of close to home. She was having just emotionally a very difficult time. And I don't think the community has done anything to help or encourage her to reintegrate, right? She writes romance novels now. She's not in legal academia, and she's so bright, and she would have been such a fantastic professor. And, you know, if she's freely chosen another occupation, that's fantastic. But it seems clear that the reason she went off the path that she was on was as a result of harassment. And part of what restorative justice needs to be thinking about is, as you see victims opting out or getting pushed out, thinking about how to reach out, how to reintegrate those individuals. So part of it, there are going to be some individuals for whom there is limited accountability, and Judge Kaczynski is one of them. But it's not no accountability, right? So the University of Illinois likes to invite all sorts of diverse speakers on various topics. I feel confident that we would not invite Judge Kaczynski, right? So in the scheme of things, that's not much of a punishment or a sanction, but it's also not nothing, right? And so you kind of make do with the best that you can until you can change the sort of larger system, which is what I'm hoping the sort of clerks group will do. And maybe a more broad way of saying this is the Time's Up movement has been really sophisticated about having sort of industry-specific subgroups. So there's a Time's Up advertising, Time's Up finance. And so each workplace kind of has its own structures, dynamics, culture, and they don't all play out in the same ways. And so collective action within specific communities, often in a way that, you know, human rights treaty is great at giving you the basic framework, the basic language, the basic ideas, but individual communities and institutions and groups are going to have to figure out how to use those broad tools in very specific settings.
I have my own.
Yeah.
So, and it's prompted in part by all of your good questions. As I was sitting, and I've thought of this before, but I'm thinking of it again today, the issue of harassment in the workplace is not new.
No.
And the issue of harassment in classrooms is not new.
No.
And the issue of violence against women is not new. And so I'm wondering, given your work in the area, to what extent you think MeToo has that this movement has sustainability? That
Yeah.
we're going to still be talking about it in 2020 and 2025, and hopefully we will have made progress, but that there will still be a voice and it won't just fade.
So what sort of gives me hope that it will have legs, though I'm not a great TLIF reader, right? I don't know. But, you know, this town hall that we had with our students, I kept playing in my mind, what would this have looked like if it had been me and my classmates? And I kind of imagined the I went to a very unique law school. So I went to Chicago, and they probably would have been like, look, if the market allows it, it's fine. But if you had gone to a normal law school, what would it have looked like in the 1990s or the early 2000s? And I kind of imagine the university offering some mealy-mouthed, we didn't know, let the process take its course, and, you know, move on. And that the students sort of as a group were so outraged, right? It wasn't just individual victims who were outraged or friends of victims. It was sort of the class as a whole sort of said, why is the institution letting this happen? And I just can't imagine that sort of widespread sentiment 30 years ago, 20 years ago. And so whether that will be sustainable, I don't know, but I feel like you all see this differently than we did. I saw it as sort of unpleasant but normal, and I think you see it as it shouldn't be normal, right? And we're willing to speak out to make it not normal. And that isn't to say, you know, the 1990s weren't so long ago, but I just, for whatever kind of cultural reason or salience, I think there was a lot of focus on sort of domestic violence in the late 1990s, or on sort of campus rape, and that was where this energy sort of focused. And I think now the energy is focusing here. Yeah. But I'm hopeful. So if nothing else, you know, despite this being sort of a litany of do not stories, I think there is real hope to be had here, and to carry that with you as you sort of go about your day.
Mm-hmm. Sorry, I didn't mean to cut in front of someone else. Any other questions, or we could just continue more informally? All right, well then again, please join me in thanking Dean Wexler for